each government sets different rules when it comes to obtaining digital evidence. Should those rules be harmonized at the EU level?
I think there should be a common framework, specifically concerning some issues. I think right now there's too much fragmentation concerning the collection of e-evidence, and what we put forward in our report is a set of suggestions, which I think maybe not all of them, but some of them might be taken into consideration when considering the issue.
So how should this harmonization look like, given that attitudes to data privacy vary between member states and harmonized approach to obtain digital evidence seems to be very hard to achieve in practice? Am I right?
Yes. I think, first of all, what we should do is setting some key principles, and then once these key principles are set, there are some logical consequences, and the principles are underlined in the report, and we specifically considering differentiating between the investigating state, so the state that can carry on the investigation, but also the member state, or well, the state more in general, who can ask a production order, so who can ask the service provider to deliver the kind of data that they can be admissible in court. And following that, we think that some definitions should be considered, should be established, and specifically definition of what is digital evidence, what is a service provider, and what it means to be offering services in the EU.
Cooperation with the United States seems to be also very important. What do you think about an idea of creating an agreement on cross-border data requests with the United States?
I think if we set the principles and then we get the definitions right, then it would be completely necessary to have an agreement with the states, and that is not easy. That would entail changes of U.S. American legislation, especially ECPA, the Electronic Communications Act. But I think it's feasible. So we have observed some recent initiatives, and they are in line with what we are proposing.